favorable treatment in U.S. courts? American companies or Chinese companies? Surprisingly, current U.S. law favors Chinese government-owned companies over American companies in all U.S. courts. In August of 2005, Hurricane Katrina, the costliest natural disaster in American history, struck the Gulf Coast of the United States. Yet little did anyone know that for thousands of those victims, their suffering had just begun. Over the next few years, 4,000 Americans affected by Katrina built new homes using drywall made by subsidiaries of the China National Building Materials Group. This drywall released sulfur emissions which forced families to move out of their homes and caused extensive health issues, including difficulty breathing, respiratory infections, and severe headaches, and among other problems amounting to anywhere from $15 to $25 billion in damage. Now, one might think that this Chinese company, responsible for harming the health of hundreds of Americans and for billions of dollars in damage, was held accountable. One might think that the harmed American families would at least have the opportunity to make their case in a court of law. However, because the China National Building Materials Group is a state-owned enterprise, meaning it is owned by the government of China, it has immunity in all U.S. courts and is therefore shielded from all liability. This story of injustice is not the first or only of its kind. It is merely the tip of the iceberg of a massive body of evidence demonstrating that Chinese state-owned enterprises are being held above the law. It is because my partner and I believe that Chinese companies doing business in the United States must be held accountable under the laws of the United States that we stand resolved. The United States federal government should substantially reform its policies towards the People's Republic of China. So how did this happen? How could our nation, which values justice, accountability, and the rule of law, allow for Chinese companies to be held above the law? Well, the answer to this question is the Foreign Sovereign Immunities Act of 1976, also known as the FSIA, codified in Title 28 of the U.S. Code. This act was intended to protect a foreign government acting in its role as a government from suing the United States, not a government-owned company. One way to think of it is that the FSIA was intended to protect nations, not nation-owned corporations. However, because of its poor wording and ambiguous terminology, Chinese state-owned enterprises, or SOEs, have construed the FSIA to shield them from all liability in U.S. courts. As international law reporter Chris Clayton put it in May 2016, federal court rulings as far back as 1995 show that Chinese corporations successfully got cases against them dropped under the Foreign Sovereign Immunities Act, a law meant to give sovereign nations immunity from being sued. Chinese companies have argued that they are part of the Chinese government, and thus also immune from lawsuits. They have used the FSIA to escape legal action on suits ranging from shipping damages, to bad drywall, to breach of contract, and defective fireworks. It is important to understand that the idea of immunity for Chinese state-owned enterprises in court is not an international requirement. In fact, besides the United States, no other country in the world gives state-owned enterprises sovereign immunity. And according to the Foundation for Economic Education, the doctrine appears nowhere in the U.S. Constitution, and some scholars argue that it is wholly inconsistent with the basic nature of America's government. Furthermore, Chinese state-owned enterprises are legally separate entities from the Chinese government. It defies logic to grant to entities legally separate from the sovereign's immunity. Indeed, even the Chinese government agrees that its state-owned enterprises are separate entities and should not be granted immunity. As the Hague Academy of International Law declared, in its present-day practice, China distinguishes the state's own activities from the activities of state corporations or enterprises. China deems that those state corporations and enterprises are separate economic entities with their own independent legal status, so they should not enjoy sovereign immunity. End quote. So the question is, why should the United States grant immunity to entities which even the Chinese government has declared should not enjoy sovereign immunity? U.S. Senator Chuck Grassley put it perfectly when he noted in September of 2016 that we must ensure that entities, whether owned by a more traditional foreign-based company or a foreign government, all play by the same rules when it comes to U.S. laws. And when state-owned enterprises are essentially using a get-out-of-jail-free card to avoid transparency and accountability through the courts, leaving U.S. companies and consumers holding the bag, changes need to be made. Therefore, my partner and I propose the following plan. Our mandate is simple. Extend U.S. court jurisdiction to include all Chinese state-owned enterprises. Extend U.S. court jurisdiction to include all Chinese state-owned enterprises. Title 28, Section 1603 of the U.S. Code shall be amended to allow all state-owned enterprises of the People's Republic of China to be sued in U.S. courts. Our agents of change are Congress, the President, and any other needed agency for enforcement. No funding will be needed as this plan is purely legislative. Our plan will be passed immediately upon an affirmative ballot, and the affirmative team reserves the right to clarify and expand upon this plan as needed. Now, there are two primary principles that individually justify the course of action proposed by the affirmative team. But together, they represent a call to action that cannot be ignored. The first is justification one: equal playing field for state-owned and private companies. Equal playing field for state-owned and private companies. Matthew Eglander of the United States Securities and Exchange Commission summed up the issue perfectly when he wrote that despite the fact that the activities in which these entities engage are essentially commercial in nature, the FSIA permits them to masquerade in the marketplace and compete with their non-state counterparts while retaining the benefits of presumed immunity. The benefits of such a presumption of immunity are extensive and create an unjust imbalance between the plaintiff and the sovereign defendant, arguably constituting the most significant problem with the current structure of the FSIA. This is precisely what our plan fixes. Under an affirmative ballot, Chinese state-owned enterprises would no longer have the unjust benefit of presumed immunity. This leads us to justification two. Removing immunity gives American companies and consumers a chance to prove their case. Removing immunity gives American companies and consumers a chance to prove their case. As U.S. Senator Chuck Grassley stated, as a result of this presumption of immunity, the plaintiff's case in New Orleans could only proceed against one subsidiary of the China National Building Materials Group, or CNBM. The case against CNBM itself was dismissed. Now, it may be that the plaintiffs still wouldn't have been able to establish liability on the China National Building Materials Group in the end, but they didn't have the opportunity, and that is fundamentally wrong. Because of the current structure of the FSIA, the voices of these Americans were silenced, and their silence is deafening. Our nation has always stood for the principle that those who break the law should be held accountable under the law. Yet our current practice of allowing Chinese state-owned enterprises to plead the sovereign immunity defense destroys that moral principle. But most of all, our current practice is the antithesis of the American way, depriving thousands of Americans of justice. Hurricane Katrina was an unstoppable tragedy, but it led to a Chinese corporation taking advantage of U.S. citizens, and that could have been prevented. By siding with the affirmative team, you'll be able to once and for all uphold the original intent of the FSIA and provide an avenue for thousands of Americans to receive the justice that they've been denied for far too long. Our nation should never have allowed for Chinese companies to be held above the law, but with your help, it won't.
Well, thank you for that, Isaac. That was a very inspirational speech. And I just want to start by saying, if we disagree with anything, I think we can all agree that wearing a blue suit, white shirt, red tie, and American flag lapel pin looks the best. Now, the first question I have for you is, in your speech, you continually said that Chinese SOEs have construed the law to allow sovereign immunity to apply to them. Isaac, my question for you is this. Who construed the law? Did Chinese companies construe the law, or did U.S. courts construe the law?
The Chinese companies, when presenting their legal defense, stated that they are part of the government, therefore they should not be, the case should not come against them.
Right, and federal courts were the ones who agreed with that.
The federal courts, because of the current structure of the FSIA, the courts, it is
right.
legally, yes. So I think
my question for you, Isaac, is quite simple. Who is the one who construed the law? Was it the U.S. courts that set precedent, or was it Chinese companies arguing in front of the judge?
Well, it depends on how you look at it. The current structure of the FSIA makes it possible so these SOEs can construe the FSIA.
Okay. In what specific part of the law?
Section 1603.
And what does it say?
The U.S.
What does it say?
It's right here. It's the section 1603 is a page long, right? Would you like me to read it?
Well, I'm asking.
It says, for the purpose of this chapter, a foreign state, except as used in section 1608 of this title, includes a political subdivision of a foreign state.
And how is political subdivision defined?
Political subdivision, well, it goes on to, the political subdivision in agency and instrumentality.
Correct.
That's defined as a separate legal person, corporate or otherwise, and which is an organ of a foreign state.
And your argument is that every federal court has accepted this interpretation, correct?
This isn't this is the law.
Right, and the federal courts have upheld that law, correct?
The federal courts, because of the current structure of the FSIA, they have been basically
Okay.
forced to uphold sovereign immunity for legally separate entities,
Thank
which
you.
is never its purpose.
And I understand that's your contention, but I do want to get this clear then. Your argument is that every federal court has agreed with Chinese companies, but only because the law is currently unclear, correct?
Actually, and you'll have to. It takes a
It's a simple
little
question,
bit to clarify. Okay, could you restate the question?
Well, I'm asking where the root cause of the problem comes from, and I find it
The root cause
interesting
of the
that,
problem is the FSIA.
okay, not based on the way the courts have interpreted that problem.
The FSIA has been set up so it has been susceptible to the interpretation of these courts because of the defendant's pleas in this
All right,
case.
you quoted Chuck Grassley several times. Does Chuck Grassley support your case?
Chuck Grassley does support the idea of reforming this so Chinese state-owned enterprises.
That's different though. Does he support your specific mandate?
The specific wording of our mandate is not supported by Chuck Grassley. The specific wording is supported by the American Bar Association.
In fact, Chuck Grassley instead proposed a different bill that applied to all companies equally, correct?
We believe the American Bar Association's proposal.
Oh, so you don't agree with Chuck Grassley's advocacy then, correct?
Chuck Grassley states that there is a problem. The reason we put it in as a problem, his solution, we believe, is not as adequate as the American Bar Association's.
Thank you. Can I get into Andrew?
Yes, thank you.
Philosopher G.K. Chesterton once articulated what he called his philosophy on fences. And the way he explained it was this. He said, if a man were to ever approach me and then point out a fence and say, that fence needs to be taken down, the very first question I should ask him is why it had been erected. And if the man was unable to provide me the reason why it had been erected in the first place, I should certainly not listen to his argument as to why it should be taken down. And I'd like to apply the philosophy of fences to our discussion of Chinese policy today. It will be my aim in this speech not so much to talk about the specific disadvantages of passing the affirmative policy, although there are innumerable. It will be my aim to explain the reason why our fence, the FSIA, has been erected, and why the reform proposed by the affirmative policy is little to nothing more than political theater. And I'll address these through a series of facts. We'll begin with fact one of FSIA. Fact one is the FSIA. It's important to note exactly what the FSIA does. Now, the affirmative speaker said that the Foreign Sovereign Immunities Act is inherently a bad thing. It's the reason why we have the problem. The law is bad. The fence is bad. But ironically enough, the FSIA is not just simply inherently a shield for abuse. The FSIA does a lot more than what you were told in the last speech. Think, for example, what James Stengel, who testified before the U.S.-China Economic Security Review Commission, said in January of this year, 2017. He said that, quote, the FSIA serves to codify in U.S. law protections equivalent to those that U.S. entities enjoy in foreign courts, as a matter of international law. Pausing there. What that means is we say that the same protections that our businesses get in everybody else's courts, we ought to afford to their businesses here. That's what the FSIA says. It's not specific to China, it applies to every country, presuming. The recognition in foreign courts of the United States' immunity from suit has long been of vital importance to United States interests, end quote. What that means, and why that's important, is that just like Chinese state-owned enterprises are given immunity or are allowed to argue immunity in United States courts, so too our businesses can argue immunity in other nations' courts. Now, the second reason why the FSIA is important is because it doesn't simply shield foreign abuse or shield foreign companies, but it also has a lot to do with private corporations as well. Patrick Gregory said in June of 2016 that, quote, the presumption that legally distinct corporate entities cannot be held liable for each other's conduct is a principle taken from general corporate law and is not unique to the FSIA. She said that private corporate defendants, also benefit from that principle, not just foreign state-owned companies, end quote. Now, the second question that we have to ask is this entire issue of state-owned enterprises themselves. Isaac told you in his last speech, in fact, that SOEs are legally separate entities, that the government doesn't own them, and in fact, even China doesn't think that they should have sovereign immunity. Every single one of those statements is simply false. State-owned enterprises are owned in whole or in part by the Chinese government. But don't just take my word for it. Take the word of the State Department Bureau of Economic and Business Affairs in July of 2016 on their article on China, who said that, quote, state-owned enterprises are considered de facto arms of the government with no independent decision-making ability, end quote. In other words, when we discuss state-owned enterprises, what we're discussing, and the reason why it's important, is that state-owned enterprises are those businesses that are owned in whole or in part by the Chinese government, by the PRC. As such, they are entitled to protections under the FSIA. Emily Fang from the New York Times said in October of 2016 that China's leaders are more than aware of this fact as well. She said that, quote, China's top leader made it clear to the chiefs of the country's biggest companies that there is only one boss who matters. President Xi Jinping announced that the Chinese Communist Party, and this is very important, has the ultimate say over state companies. He said that party leadership and building the role of the party are the root and soul for state-owned companies, end quote. So it is very clear that state-owned enterprises are in fact owned by the government, are in fact directed by the government of the PRC, and as such are entitled to a sovereign immunity claim. Now that's the important point that we have to address next, is what is sovereign immunity? Because the way that it was represented in the last speech, the way it sounded, is like Chinese companies can just walk in and they don't have to be sued. They can't be sued in foreign courts because of the FSIA, because of sovereign immunity. But fact 3 is SI equals defense. SI equals defense. The sovereign immunity and the protections that are allocated to it under the FSIA are as an affirmative legal defense. What that means is that when we're talking about sovereign immunity, the way that it would work in court is that I could sue CMBM over the drywall case, for example. They would be sued, they would be brought to the court, but they would have the opportunity to make a legal defense, just like Simon and I have the opportunity to make arguments against the affirmative speakers. Now, just because we choose a certain argument, for example, the argument that China controls SOEs, doesn't automatically mean we win just because we said those words. In the same way, sovereign immunity doesn't mean that Chinese companies automatically win their suit so that they can't be sued. All it means is they have a right to claim sovereign immunity, and the court will then weigh that claim and say, do you really have sovereign immunity, or are you acting commercially and you don't get sovereign immunity? That's what the SI doctrine is. It's not an automatic win, and it is an affirmative legal defense. And the impact of this is that sovereign immunity, rather that state-owned enterprises are entitled to that defense. Now, the fourth fact that I have for you is current application. Fact 4 is current application. According to the transcript of a hearing before the U.S.-China Economic and Security Review Commission on January 26, 2017, James Stengel testified before Congress saying that, quote, first of all, the court decided in a case called Dole v. Patterson that to qualify as an agency or instrumentality of a sovereign nation and to be sovereign itself, the enterprise must be majority owned directly by the state. That is, subsidiaries of state-owned enterprises do not enjoy immunity under the Act. That takes out, as a practical matter, a vast range of SOEs, indirect state-owned enterprises doing business in the United States, end quote. What this means is that the actual number of cases we're talking about here is very, very small. The FSIA is aware that those SOEs that don't have government control, they shouldn't get sovereign immunity. They're not allowed to argue it. Only the ones that are government-controlled may argue sovereign immunity. As a result of this, the arguments are very few and far between. He continued to say that, quote, although in some circumstances Chinese SOEs are entitled to immunity in U.S. courts under the FSIA, the instances in which they have actually availed themselves of that protection are few in number and make up only a small number of the overall number of cases in which a foreign state or its SOE asserted immunity under the FSIA, end quote. He went on to say that there are probably 10 or 15 cases ever of a Chinese state-owned enterprise actually making the argument of sovereign immunity in United States courts. And that's not even the number that won. So that's what we're dealing with here. Sovereign immunity is entitled to any foreign government, not just China. The affirmative team's plan says that just China is making a big deal about it, and it's happening so often, there's so much abuse, that there has to be some sort of change. But even let's assume that all of that is true. If all of the harms are true, that's why it's so concerning that the only solution the affirmative team offers you is political theater. And that's my disadvantage, is political theater. But look, the mandate of the affirmative team's policy is simply to say, extend U.S. jurisdiction to include all SOEs. All that it does is say that under their plan, SOEs may be sued. Ladies and gentlemen, they already can. That's kind of the point of the affirmative team's case. Under the FSIA, SOEs can still be sued, but they also have the opportunity to make a defense which the court weighs. The affirmative policy does absolutely nothing to change that. Their policy is feckless, it's based on a failed problem, and it shouldn't be passed. Thank you very much.
Benjamin, should entities legally separate from the sovereign be granted the sovereign immunity?
If they're legally separate, no, they're not.
Can I see part of evidence immediately?
Which one?
The part of evidence about how basically you construed it to say that they are part of the government.
Well, sure, I have three. One of which was when the president of China saying they're not. So which one do you want? I'll just give you one. Yeah.
The specific one, you made the claim that in my last speech I stated that state-owned enterprises are not owned by the government. Where in my speech did I say?
You said state-owned enterprises are legally separate. And to be fair, I wrote that down. I don't know if it's in your 1EC. I can check that.
Now, is being owned and being a part of the government two different things?
You said they were legally separate entities. And that's not.
Did you respond to the article by the Chinese government itself and by the Hague Academy of International Law that stated that Chinese state-owned enterprises are legally and economically separate from the sovereign?
Actually, Simon actually is going to respond to that in the next speech as to why that specifically said it is an issue.
Now, when we look at the credibility of authors, you would agree that a person who works for a Chinese state-owned enterprise has a vested interest in saying good things about that entity.
Sure, I would also agree that if one is the president of a Chinese state-owned enterprise, they're also a member of the Communist Party of China, which is another interesting fact.
Do you know who James Stengel is?
I do, yes. He's a lawyer. Lawyers work for a lot of people.
Did you know that James Stengel, he does, yes, did you know that James Stengel is the lead attorney for the China National Building Materials?
He was, and yes, that is correct.
Now, should
And that's why he would know how many times sovereign immunity is used.
All right, thank you.
Sure.
Now, should victims have an opportunity to make their case in court?
They do. Yes.
So we talked a little bit on your third point that sovereign immunity is a defense, and under your logic, they do have a chance. Do you know when you stated the court basically weighs that claim of sovereign immunity? When in the litigation process does the court weigh that claim?
When they're winning the case. What's your question?
At what point in litigation does the court make the decision on whether an entity is part of the government or not, or part of the sovereign?
Well, it would depend on the information that they garner. There's a fact-finding process. They have to determine the relationship between the parent company and the child.
Did you respond to the card of evidence in my first speech under the second justification from U.S. Senator Chuck Grassley that stated it's at the very onset of litigation, before the discovery process?
And this is the one about CNBM particularly. And no, I definitely did not. But that's again particular to the CNBM case. And again, the argument here is not that the time matters when it's weighed. The argument is that you can still sue, and that's CNBM was sued. Your plan is just to allow people to sue them.
You would agree that many claims by plaintiffs are very fact-dependent, correct?
Sure.
Now, the fact-finding process is the discovery process in litigation.
That is correct.
All right. If the issue of sovereign immunity is determined before the discovery process, before the fact-finding process, is that unjust?
Well, first of all, I know for a fact that it's not. In CNBM, It was during the fact-finding process, and we can present you the entire CMBN case if we have to discuss that. But the important argument here is that the only thing your case does is allow them to be sued. It doesn't affect fact-finding. Yes. Thank you so much.
Everybody all set? Timer? Matthew Englander of the United States Securities and Exchange Commission summed up the issue perfectly when he said this: "No other international jurisdiction affords legally separate entities presumptive immunity. Rather, most nations have expressly rejected this notion. Thus, the presumption of immunity under Section 1603 runs directly contrary to the modern international practice for conferring sovereign immunity. In this sense, the current structure of the FSIA does not achieve its purpose." End quote. And it's because my partner and I agree with Matthew Englander of the United States Securities and Exchange Commission that no other nation gives immunity to entities that are legally separate from the sovereign, in this case, state-owned enterprises, and that the U.S. should be no different, that we would ask you to side with the affirmative team at the end of today's debate. Throughout the entirety of this round, every argument that we as the affirmative team will present to you will come down to this one principle, this one fundamental belief that we would ask you all to ultimately make your decision upon, and it's this: we believe that entities legally separate from the sovereign should not be granted the sovereign's immunity. I'll repeat that. Entities legally separate from the sovereign should not be granted the sovereign's immunity. In other words, my partner and I believe that if an entity is not a part of the government, it shouldn't be given immunity as if it were. So the question is this: are Chinese SOEs a part of the Chinese government? According to the Chinese government themselves, the answer is no. For clarity, let me reread the Code of Evidence my partner read in his last speech. According to the Hague Academy of International Law, quote, "In its present-day practice, China distinguishes the state's own activities from the activities of state corporations and enterprises. China deems that those state corporations and enterprises are separate economic entities with their own independent legal status, so they should not enjoy sovereign immunity, end quote. So the question is this. Why should the United States government continue to grant immunity to entities that even the Chinese government has said should not enjoy sovereign immunity? We believe the answer is very simple. It shouldn't. With that being said, let's move on to the very first argument presented by the negative team, which is that we need to always keep in mind why the fence was put up to begin with. And they read a part of evidence from James Stengel talking about the history of the FSIA. And I'm glad they brought up evidence from James Stengel because I'd like to inform you about who he actually is. I have 2 points under the issue of James Stengel. The first is he's the lead attorney currently representing the China National Building Materials Group in the drywall litigation pending in the Southern District of Louisiana. My second response is that he has a as the client, or as the attorney representing the client CNBM, he has a fiduciary duty to not take a position contrary to his client's interests. And I'm sure many of you are familiar with what a fiduciary duty means. But the second point under this issue is the evidence that Ben read in his last speech said, according to James Stengel, that U.S. businesses receive the equal protections or protections equivalent to what Chinese entities receive in U.S. court. This is simply not true for 3 reasons. My first response is that the U.S. doesn't have SOEs. The U.S. doesn't have SOEs, so China does not give our state-owned enterprises sovereign immunity. My second response is China doesn't give our private companies sovereign immunity. They said, well, our businesses can argue sovereign immunity. My simple response is that they can't do it successfully. There's not been a single instance provided by the negative team of a U.S. private company ever successfully asserting the sovereign immunity defense. We'd love to see that evidence if they have it. My third response is that China has said that their SOE should not receive immunity, so the fact of the matter is, why are we continuing to do so? This leads me to the next main point, which is that SOEs are owned by the government. So therefore, they must be not independent. They must not be legally separate because they're owned by the government. And while this sounds like a logical argument, let's look at the 2 parts of evidence they read. The first part of evidence said they're the de facto arms with no independent decision-making. So it's talking about the decision-making. The second part of evidence was from the president of China, and he said that he has the ultimate say over what SOEs do. Once again, what they do and their decision-making. But we can completely agree with both of those parts of evidence, but that does not make them not legally separate from the sovereign. Just because the sovereign has control over what they do, when it comes to whether or not they can be sued legally they are separate from the sovereign. And so the fact is, although the sovereign may have a large role in what they do, that does not make them independent legally from the sovereign, and the negative team has yet to provide evidence to support this. This leads me to the next argument of the sovereign immunity equals defense. Sovereign immunity equals defense. And their point under this was that U.S. citizens can make their case. And the simple answer is no, they can't. The evidence went completely unaddressed, and my partner read in his first speech how the case is dismissed before factual discovery. The case is dismissed before factual discovery. According to U.S. Senator Chuck Grassley, he says this: now, it may be that these plaintiffs still wouldn't have been able to establish liability on the part of CNBM in the end, but they didn't have the opportunity. And that is fundamentally wrong. We never claimed specifically that the claims were even legitimate against the CNBM. The evidence just merely says they didn't have the opportunity to make their case, and that's the problem. Throughout the entirety of today's debate round, we will never claim that a claim against an SOE is necessarily always legitimate, because many times there are frivolous litigation. But the fact is they should have the ability to make that claim, and according to the Stanford Law Review, the fact of the matter is that they don't. According to the Stanford Law Review, in the context of foreign sovereign immunity, courts have consistently held that issues of immunity must be resolved at the earliest possible moment in litigation. The article continues saying this: consequently, without significant discovery, plaintiffs are often unable to prove an exception to the FSIA. Proof of an exception to immunity is highly fact-dependent and may require evidence that is in the exclusive possession of defendants, end quote. The fact of the matter is that just because it's a defense, there's no proof by the negative team that U.S. citizens can actually make their case. And we can see that, yes, jurisdictional discovery is allowed, but that's only to determine whether or not they're actually a part of the government, or not part of the government, but are under the FSIA, considered to be a part of the government. And then once we determine that the case proceeds. This leads me to the next main point of the current application. Once again, they read a part of evidence from James Stengel, and I have the evidence right here if they'd like to see that he is the lead attorney representing the CNBM. But they said that SOEs have to be a majority owned to receive immunity. And my simple response is this: even if they're a majority owned, they're still legally separate, and the negative team has yet to provide evidence that they aren't. Then they read a part of evidence once again from James Stengel saying that the immunity claims are few and justified. And of course he would say that, he's representing the CNBM. But my simple response is that immunity claims for entities legally separate from the sovereign can never be justified. When you are an entity that is legally separate from the sovereign, a claim to sovereign immunity is never justified, and it doesn't matter how few times this happens. We have case after case we can hand to the negative team if they'd like to see it, when this has happened in just one case it denied 4,000 Americans justice in the Katrina case. We have another example of 50 to 100,000 veterans of Operation Desert Storm who were denied justice in a class action lawsuit against another Chinese SOE. So it doesn't matter that this is only a few times. Each one of those instances has denied thousands of Americans justice. And this leads me to their final argument of political theory. They said, well, they can already be sued. But my simple response is this: they cannot be sued like regular companies can be, like private Chinese companies, like private American companies. And by extending U.S. court jurisdiction, what that means is we give them the same protection that we would give private Chinese companies. We give them the same protection we would give a private U.S. company, and we give them the same equal treatment under the law. That's why we presented this policy to you today, is because we believe in equal application and equal treatment under the law, and we believe that victims should never be silenced, especially before they've had the opportunity to make their case in a court of law. So the question is this: should entities legally separate from the sovereign be granted the sovereign's immunity? My partner and I contend the answer is no, and we hope you do as well. Thank you.
Robert? First of all, Samuel, congratulations on making it to finals. So I do want to discuss, thank you, I want to discuss the case that you brought up and the arguments that you presented. Let's begin with the issue of litigation. What does it mean to be able to sue someone?
To be able to sue someone means your case can be heard in a court of law, and by our mandate, what we meant, and what will actually be happening, I mean, this is a team policy debate, is that under an affirmative ballot, they will receive the same protections that private companies get in the U.S.
But let's look at what your mandate says. The mandate is the bill that you're passing, correct? Could you read for the judges what your mandate says?
It says to extend U.S. court jurisdiction, but as you may recall, in the 1AC, we said we can expand upon and clarify our plan in future speeches. This is clarifying what the intent of our plan is, and that is to give the same protections as private companies.
Going back, all I want you to do is read what your plan says. Could you read it, please?
Sure. Our mandate is simple: extend U.S. court jurisdiction to include all Chinese state-owned enterprises. This is the actual text of our plan.
Yes.
Title 28, Section 1603 of the U.S. Code shall be amended to allow all state-owned enterprises of the People's Republic to be sued in U.S. courts.
And that was the
And then I would note the mandate goes on to say this: our plan will be passed immediately upon affirmative ballot. The affirmative team reserves the right to expand upon and clarify this plan as needed. And it's clearly it needs some clarification. So I hope I've given that to all.
Okay, and I would agree it does need some clarification, because I hope we do agree that Chinese SOEs can be sued in U.S. courts today, correct?
Actually, technically, they can. If they assert the sovereign immunity defense claim, they cannot be sued in U.S. courts.
So
because it only comes to a jurisdictional fact finding.
Samuel, what is currently happening with the CNBM case, in which they claim sovereign immunity?
And the CNBM was dismissed. Right now,
You said it was currently being litigated in your speech. Is that not correct?
the subsidiaries are currently in pending litigation.
So the lawsuit is still going on. CNBM is still on trial.
No, it's not. Subsidiaries are being sued, and as my partner read in the evidence from U.S. Senator Chuck Grassley, the subsidiaries were able to be sued.
Excellent. The subsidiaries would be the ones that weren't government-owned, unlike CNBM, correct?
The subsidiaries are not government.
Excellent. And so you would agree with our evidence then that says that when presenting a sovereign immunity claim, the court weighs whether the organization or the person claiming sovereign immunity is government-owned, correct?
Under the current structure of the FSIA, all that is required is government-owned, not whether or not they're actually a part of the government, which I read evidence that they're legally separate from the sovereign.
Excellent. All right, so now let's move on. Let's talk about that specific argument right there. The Chinese government saying that they don't even think their company should be allowed sovereign immunity. When did the Chinese government say that, and whom in the Chinese government?
This has understood since 1979.
Okay, then why did President Xi Jinping seem to disagree last year?
I understand that you think he disagreed. What he said is that we have the control over what they do, not when it comes to U.S. courts. He never said that we have the ability or that we want them to receive immunity. All he says is that we have the final say over what they do. According to the evidence we read, it says we have the ultimate say over what they do.
Who appoints the board of directors for Chinese state-owned enterprises?
It doesn't matter if you're right, the government of China does do that, but it does not make them a part of the government of China just because the government of China appoints their board members.
Thank you, Sam.
All right, looks like everybody's ready now. I think what we just learned from that cross-examination, ladies and gentlemen, is that everybody in this round, everybody standing before you is very passionate about their side. And I'm reminded of the words of Abraham Lincoln when he said, "Though passion may strain us, it must never break our bonds of affection." Ultimately, I agree wholeheartedly, and I believe that Samuel and Isaac in this round have the American people's interests at heart, which is why I find it difficult for me to have to analyze their case, because ultimately, though their hearts are in the right place, their mandate is not. Because the Affirm team has told you that their mandate needs clarification, and it certainly does. The Affirm team has told you that their plan will prevent companies from claiming sovereign immunity. It certainly won't. The Affirm team has told you that companies right now are claiming the sovereign immunity dispensed almost only by China. They certainly aren't. Ladies and gentlemen, the Affirm team has the correct intentions. But I remind you, if you check off the Affirm ballot today, you are not voting for their intentions. You are not voting for good rhetoric. You are not voting for passion. You are voting for the words of the Affirm mandate. Words that the Affirm team seeks to change in the round because they needed it to be clarified when we pointed out there are massive problems with it. Here's the bottom line, ladies and gentlemen. I could give you half a dozen arguments against their case that they've probably heard all year. I'm not going to do that. I'm going to focus only pretty much on the wording of their mandate, because this is the most important issue. What they said in the cross-examination was that their case will treat Chinese SOEs the same way private businesses are treated. That is nowhere, and I repeat, nowhere within their mandate. Samuel and I both agree that their mandate needs clarification, but that clarification should have come at the beginning of the round, not in the second speech where they're now trying to change what their case and what their mandate actually does. So just one more time, and it took the Affirm team a while to actually be willing to read the mandate, so I'll do it one more time. It says our mandate is simple. Extend U.S. court jurisdiction to include all Chinese state-owned enterprises. Title 28, Section 1603 of the U.S. Code shall be amended to allow all state-owned enterprises of the People's Republic of China to be sued in U.S. courts. Let's stop there for a moment. Remember what Samuel said when he defined what the word sue means? To be heard in U.S. court. Remember what we also learned in the cross-examination. The Hurricane Katrina case is currently being heard in U.S. court. In fact, nothing about their mandate allows or prevents any company from actually successfully claiming the sovereign immunity defense. Right now, companies can claim it. Right now, Chinese SOEs can be sued, as CNBN was, as Taishan was, as the Gulf War veterans case they referred to. That was actually a case that went before a federal court called Coleman v. Alcalac. So, ladies and gentlemen, the problem right now is not a lack of being able to hear a case in U.S. court. The problem is whether that is going to be successfully granted, whether the sovereign immunity defense will be granted. And they can clarify and say, well, we're just not going to let it happen, but that's not the same thing, ladies and gentlemen. So I must quickly also address this notion by the Affirm team that they can expand upon their mandate in the middle of a team policy debate round. Quite frankly, that's not the case at all. Otherwise, if we just pointed out dozens of problems with their case, they would get up and say, well, we realize there are problems, so we're going to try to fix it in the middle of the round. What they mean is that they can clarify their mandate, but there's nothing here to clarify. Their mandate is extraordinarily clear. They are going to allow state-owned enterprises to be heard in U.S. courts. That is absolutely not the same thing. So their case does nothing. Their case does absolutely nothing. And interestingly enough, they've told you that this plan is advocated. Well, first they said it was advocated by Senator Chuck Grassley, of course. Then Isaac corrected himself and said that's not true at all. The idea of changing sovereign immunity is supported by him. Then they pointed me and read a piece of, actually they didn't even read it, they referenced a piece of evidence from the American Bar Association, which they allege supports their case. Now, I remind you, and I've read the mandate again and again and again, so I want you to remember the mandate. Now let's listen to what the American Bar Association, their only advocate, says. It says, the working group's view is that the legal characteristic test is a more appropriate test. It is the standard established by international law and is supported by a substantial body of case law that makes it the most consistent and predictable test. Ladies and gentlemen, this piece of evidence is talking about a certain characteristic legal test being used in U.S. courts, something never specified by the affirmative mandate. Instead, and this leads to the first disadvantage I have, if you vote for the Affirm team's case, you are voting for one of the most unrealistic policy reforms in U.S. policy with China in history. The first point I have is that of a fake accusation. let's talk about the Hurricane Katrina case that the affirmative brought up. The U.S., and this is a direct quote from the actual case being litigated, once again to disprove the affirmative's argument that you can't even hear these cases. They're actually published. That's why the affirmative has a list of those cases they offer to us. Let's read what it says. It says, CNBN Group has never manufactured, inspected, sold, supplied, marketed, exported, or delivered drywall. Neither Tyshan nor BNP and PLC ever consulted with CNBN Group regarding their decision. Pausing there. In other words, what this is saying is that of course CNBN shouldn't be sued because they in no way had to do with the contracting of drywall related to the victims in the Hurricane Katrina case. That's why this sovereign immunity was granted to CNBN. So we see that there's no advocacy for their case, but let's understand even for a second. Let's allow Samuel to clarify his mandate in the middle of a round for a moment. Let's do that. Even if we grant him that ability, which he certainly does not have, but even if we did, let's understand what their case would be doing. It would be reforming U.S. code to explicitly prevent Chinese SOEs from being sued in U.S. courts. And the reason that's important, ladies and gentlemen, is because that's not how laws are written. The United States government does not write laws specific against Chinese companies and say that all other countries on the face of the earth could claim this exact offense, but because it's China, we're not going to allow it. In fact, there's plenty of evidence to say that this would actually be illegal under international law, and that's the second point I have for you. This would violate our international agreements under the World Trade Organization. Professor Michael Trablock points out the most favored nation obligation calls for a country to grant every other country with which it is signed an MFN treaty the most favorable treatment that it grants. It also prevents discrimination. Now, ladies and gentlemen, what their case is doing is explicitly codifying in U.S. law discrimination against one type of company within the People's Republic of China. This is further evidenced by the fact that, remember, ladies and gentlemen, there are dozens and dozens of countries that have state-owned enterprises. Oftentimes, they claim sovereign immunity in U.S. courts. So the affirmed team, if their case truly is about justice for American citizens, why are they specifying it to China? They're saying that if a Venezuelan company violated U.S. law, which has happened before, and this went before the case, the affirmed team would tell you that they should be granted sovereign immunity. So the affirmed team's case isn't about justice. It's about partial justice. But even then, it's not, ladies and gentlemen, because their case does nothing. Their case does not change a single thing about whether the sovereign immunity defense will actually be granted. So it's illegal because it's codifying in U.S. law specific discrimination against a specific country, something that has never happened before in regards to the Foreign Sovereign Immunities Act, something the affirmed team can't provide advocacy for. Instead, what they've told you is that their claim needs clarification, and it absolutely does. But they should have done that at the beginning of the round. So here's what I'm concerned about. I'm concerned if I point out another problem, all the affirmed team is going to do is re-clarify their case and fix the problem. And that's not what debate is about, ladies and gentlemen. So once again, both teams are passionate. Both teams are excellent orators. But the question before this court, the question before these judges is whether you will vote for the affirmative mandate. And their mandate needs clarification. They should have given that to you. They did not. Thank you.
My first question for you is, should entities legally separate from the sovereign be granted the sovereignty?
Nope.
There's some part of evidence that these Chinese state-owned enterprises are not legally separate from the sovereign.
Yes, we read a quote from the president of China saying that they are indeed connected with one another directly.
Connected. Now, did it say that they were a part of the Chinese government, or that the Chinese government had the power over its decision making?
It said they were part of the Chinese government in two ways, yes.
It said that they were part, word for word, they were part of the Chinese government? Or did it say the Chinese government controls its decision making?
Well, first I'll point out, no piece of evidence read by either you or me has said that they are specifically a part or not a part. You read a piece of evidence saying they're legally different from one another. That's something that China
legally different, or did it say legally separate?
It said legally separate.
Okay. And if it was another way of saying separate, not a part of something?
Well, once again, that would be incorrect considering the Chinese government directly disagrees with that assessment.
The only evidence you've read is something about the decision-making process, correct?
Once again, incorrect. We read three pieces of evidence about both from the legal
decision-making process, correct?
about the decision. No, not about the decision-making process alone. It directly talked about how Chinese SOEs are oftentimes, like CNBN, have the board of directors appointed by the Chinese Communist Party.
So the board of directors are appointed, does that mean they're part of the Chinese government?
Once again, yes, it does. And yes, and if you want us to read more evidence about that, we certainly
I would
can.
love to see evidence saying word for word they're part of the Chinese government. Now, talking a little bit more about the evidence that SOEs, or talking about our plan, because you seem to have a problem with the way we phrase our.
Actually, you did.
Oh, okay. Does the U.S. have jurisdiction under the current structure of the FSIA over the agencies and instrumentalities of the foreign state, which includes a separate legal person?
That was a super long question.
Does the U.S. courts have jurisdiction over the agencies and instrumentalities
Of foreign courts?
of foreign states?
No, they don't have the power over foreign states.
So under the current structure of the FSIA, the U.S. courts do not have jurisdiction over what the FSIA deems as agencies and instrumentalities, correct?
Once again, as I was about to say, once an SOE engages in commercial activity in the United States, then that submits them to jurisdiction of the U.S.
I'm
law.
aware of the commercial activity exception of the FSIA. I'm talking about specifically though, if the commercial activity exception can't be shown under the current structure of the FSIA, does that mean that these state-owned enterprises are immune?
Once again, if a SOE is engaging in commercial activity, they certainly have the right to make that claim, where it will then be litigated, just like under your mandate.
Now, you said that the CNBM was never involved in this drywall, correct?
Correct. And actually, I didn't say that. The district court regarding that specific case said that.
Now, how much discovery was in that specific court's case?
You're correct in saying that
It was just jurisdictional discovery.
it was jurisdictional discovery, right? And that's something your claim would not prevent once again.
My final question is, you said this is an unrealistic policy. Now, before the FSIA, are you aware of what the Supreme Court advocated for?
Before 1978 is what you're asking?
1976, when it was enacted.
I'm not familiar with what the Supreme Court advocated regarding U.S. foreign policy. That's the job of Congress and the executive.
Okay, thank you so much for your answers.
And one of the words that you've heard a lot during this debate, and I'm sure you'll continue to hear used by Isaac and Samuel throughout the rest of this round, is justice. And it's because that word is very powerful. When we hear the word justice as American citizens, it stirs something up in you that feels good. But when I hear Isaac and Samuel use this word, I'm reminded of something else, and it's the words of Inigo Montoya from The Princess Bride. You use this word often. I do not think it means what you think it means. And what I'd like to show you in today's debate round is that justice is important, justice is vital, and that's why we have to understand the reason why the fence was erected. what the FSI is, what the FSI does, and why the interpretation of the law under the affirmative team would be discriminatory if it actually does anything. What I'd like to do is boil the round down as we move into the rebuttals through a series of main arguments. And the first of these is the purpose of the law. The first main argument is the purpose of the law. The purpose of the FSIA is not to protect Chinese companies. It is not to give Chinese companies free rein in the United States courts. It doesn't have anything to do with China specifically. The FSI is specifically to entitle sovereign states and the companies they own to the protections that they deserve. And it would be the same protections that United States companies would receive reciprocally in any other nation. That's the purpose of the FSIA. And that's the first reason why it's concerning that even if you assume that the affirmative policy would change anything, it's not changing what they're telling you. And Samuel, in fact, in cross-examination in his last speech, continued to hone the issue of legal separation. He said, companies that are legally separated from their sovereigns shouldn't be able to claim immunity. But their case doesn't do anything about that. Their case says that Chinese companies, Chinese SOEs, whether legally separate or not, shouldn't be able to claim sovereign immunity, or at least should be sued in the United States court. So if the issue is truly legal separation, why are we only focusing on Chinese issues and not the issues from any other sovereign immunity, or any other sovereign immunity claim, or any other state enterprise from any other nation? And my second argument for you today is the nature of SOEs. The nature of SOEs. There's the issue of directed by the state, legal separation, etc., etc. And I'm reminded of the words of Roger Robinson from the MacDonald Laurier Institute in June of 2013, who said, quote, the expression, let's not kid ourselves, comes to mind when Chinese companies seeking business overseas go to great lengths to cast their relationship with the Chinese government as remote, separate, and independent, end quote. Furthermore, Samuel asked for specific evidence that had been read or could be read about legal separation. I've already read two, and I'll bring these up to you now. The first is from the State Department Bureau of Economic and Business Affairs in July 2016 that says that, quote, according to the United States government, quote, SOEs are considered de facto arms of the government with no independent decision-making ability, end quote. Furthermore, they never responded to the court case Dole v. Patrickson, and this is a very important argument. Dole v. Patrickson was a court case that specifically established the criteria for determining which agencies, which state-owned enterprises receive sovereign immunity. I'll read it once more. Dole v. Patrickson decided that to qualify as an agency or instrumentality of a sovereign nation and to be sovereign itself, the enterprise has to be majority owned directly by the state, end quote. In other words, if a company is majority owned directly by the state, which the affirmative team agreed that SOEs are, then according to our courts and according to our laws, it is state-owned and it is a part of a sovereign nation. So according to our court precedent, according to our laws, and according to our evidence, SOEs are state-owned and therefore are entitled to sovereign immunity. The third argument for you today is that of current application. What is the current application of the law, and why do we have an issue with the affirmative team's interpretation of it? We talked about James Stengel in the last speech, and Samuel basically said James Stengel is a lawyer who's defending CMBM, and therefore his opinion shouldn't be counted because he has to say those things. But that's actually not the case. What James Stengel was doing was testifying before the U.S.-China Economic and Security Review Commission. He wasn't saying that sovereign immunity is good. We didn't read from him saying that China shouldn't even have sovereign immunity. What we read was his argument that China has only even argued sovereign immunity 10 to 15 times ever out of the hundreds of times that other countries have argued it. Furthermore, he said that that's not even the number of times they've actually won the argument. In other words, they've lost it sometimes too. So sovereign immunity is not a guaranteed win, and it certainly doesn't deprive anyone of their day in court, as illustrated by the fact that the CMBM case is still being litigated in courts right now. They said that CMBM is government-owned and can't be sued, but the subsidiary companies, the child companies can. They are being brought to justice. So again, we can sue right now. And that leads me to my fourth and final argument of political theater. Political theater. Quite simply, if everything the affirmative team says to you is true, then that makes their mandate that more grievous. The fact that their mandate only says that Chinese companies will be allowed to be sued in U.S. courts, like they already are, does absolutely nothing to do with any harm, any problem with the current situation that they have identified. So don't just use political theater and rhetoric and the word justice to justify a plan that is discriminatory and wrong. Thank you very much.
I'd like to tell you the story of a man by the name of Robert Silverman. Now, on July 4th, 1994, Robert Silverman was celebrating the 4th of July, the founding of our nation with his family, when a defective firework blew up in his face, mauling his face, his left arm, and his legs. Robert Silverman now walks with a cane and can no longer hold a normal job. He was 31 years old. Now, Robert Silverman believed that the principles of justice for all and equal application of the law that he was celebrating on that 4th of July weekend would apply to him. He believed that the company that changed his life forever, the company that manufactured that defective firework, would be held accountable. He believed he would receive some form of compensation. But because that company was owned by the government of China, it was granted immunity, and Robert Silverman received nothing. We believe that is fundamentally unfair, unjust, and ultimately un-American. Ben stated that we don't know the exact definition of justice, or the idea of justice that the affirmative team has isn't really what justice is. But the story of Robert Silverman, if it is the contention of the negative team that is just, we believe that is not the American way, and that's certainly not the justice the affirmative team advocates in today's debate. I'd like to examine the idea that our plan doesn't really do anything, because I don't think that is the case. When you look at the wording of our plan says our mandate is simple. The United States shall extend U.S. court jurisdiction to include all Chinese state-owned enterprises. So the question is, does the United States currently have jurisdiction over state-owned enterprises? Because that's what our plan is doing. If we already have jurisdiction over these entities, then sure, our plan isn't doing anything. But according to Pullman versus Appalach, which is the case with the Gulf War veterans, the reason why it was rejected is because they don't have jurisdiction, according to the reason for decision. Having found no exception to the FSIA as applicable in this case, this court necessarily finds it lacks subject matter jurisdiction. The plan of the affirmative team is changing this. Under the current structure of the FSIA includes agencies and instrumentalities as separate legal persons. Now, it defies logic to grant to entities legally separate from the sovereign immunity. And yet the current structure of the FSIA, according to the FSIA, it grants sovereign immunity status to entities who are legally separate. And so this moves into the second point. What is legally separate, and are Chinese entities legally separate? Well, the definition of legal separateness, according to the International Litigation Committee of the Section of International Law and the Practice of American Bar Association, the court found that the plain meaning of separate legal person, part of the definition of agency and instrumentality under the statute, was the entity could operate independently of the state. The court referred to the legislative history, which noted that instrumentalities are entities that could sue or be sued, contract, or hold property, and said that these legal characteristics should hold the basis for the test. That is fulfilled by, according to the Chinese government, and according to, as the course of evidence that my partner and I have both read in today's debate round from the Hague Academy of International Law, Chinese state-owned enterprises fulfill this test. And they stated, they have part of evidence that stated that Chinese entities are de facto arms of the government. And that may be the case. But de facto means as a fact, not of law. We were looking at the legal characteristics, not maybe what they are what they are. We're looking at what they are under law, not necessarily how much control the government has over them. We agree that as a communist nation, the Chinese government does have control over these state-owned enterprises. But as the Chinese government has consistently stated, they are separate economic and legal entities. And so the question remains, should we grant immunity to entities that are legally separate from the sovereign? We believe that the answer is no. The next point I'd like to talk about is the drywall case. They stated that the China National Building Materials Group did not make this drywall. And I would like to point something out here in today's debate round. And Simon and Ben have done this in every single one of their speeches. They have stated something, but they've not read the entirety of the evidence, or they've stated the affirmative team's position, which is simply not true. And in one example, Ben in his first speech stated the position of the affirmative team that Chinese state-owned enterprises are not owned by the government. We never stated that. And yet he began his speech by stating that quote-unquote fact. But also in Simon in his last speech, he quoted a part of evidence from the court decision that said that the court ruled that China National Building Materials Group didn't make the drywall. That's simply not what the court ruled. According to the reason for decision, the court ruled that the plaintiffs couldn't prove that the China National Building Materials Group made the drywall. Those are two very different things. The reason they couldn't prove that, as the court further noted, is because there was no sufficient fact-finding. Because there was only jurisdictional discovery and not actual factual discovery. And as my partner read in his last speech, there's two completely different things. The final point is that of a violation of international law. He said it violated most favored nation status. That is under the World Trade Organization. That deals with tariffs and not laws domestically in the United States dealing with the legal system. The policy of the affirmative team fulfills the status of significant reform because it provides an avenue for thousands of Americans to receive the justice that they've been denied for far too long. Thank you.
I'd like to know what the Affirm team would say if Robert Silverman were here. What would they tell him? Would they look him in the eyes and would they say, you have the ability to sue China? If so, all Robert Silverman would reply is, I already have and I already tried. And if you vote for the Affirm team's case, his response would be no different. Because if the Affirm team's case is about justice, then Robert Silverman is certainly entitled to it. Not half justice, not partial justice, but full justice. Justice that will never happen in an affirmative world. And I find it now interesting that the Affirm team seems to disagree with one another. Samuel believes his mandate is in need of clarification. Isaac does not. If there's one thing we do agree in this round, it's that the Affirm team's mandate is very simple, as they said. But unfortunately, because of its simplicity, it is not the policy that they have now clarified. And so I'd like to address this, but before I do so, Isaac made the accusation that in this round we've consistently only read parts of evidence. He's also said we haven't read evidence for many of our accusations. Now, you can be the ones who determine whether or not that's true, but I find it ironic. He made an accusation about the C&BN case without reading from the court case, or at least the part he left out specifically, and for you with legal experience, you'll understand the importance of this. It says, having found no exception to the FSIA applicable in this case, this court finds it lacks subject matter jurisdiction. As a result, the court has no choice but to remand this case to the state court where it was originally filed. Ladies and gentlemen, this case was never dismissed. It was remanded back to a lower court case to be heard because they said they lacked subject matter jurisdiction. That is completely different from the case being dismissed and a Chinese company never being held accountable. So I have 3 voting issues for you today. The first voting issue is that this is a feel-good policy. A feel-good policy. Let's go back to the mandate. The mandate says that what their case is going to do is allow Chinese SOEs to be sued in U.S. courts. They can already be sued in U.S. courts, and when they are sued in U.S. courts, they claim the sovereign immunity defense. When they claim the sovereign immunity defense, according to the Affirm team, China overwhelmingly wins. Now, I remind you again that dozens of other countries also win that their case would never affect. But their plan does absolutely nothing besides say, you are able to be sued. And once again, Samuel can try to clarify his mandate all he wants, but it doesn't change the text of the mandate, which is that, and Samuel even defined being sued as to be heard in court. Every time when C&BN was sued, they were heard in court. When Robert Silverman sued, that was heard in court. When the AVIC case they brought up, that was heard in court. That's why, again, the Affirm team says they have a list of all the cases. Now, if their plan were to create a regulation, making, for example, in the immunity exception or waiving clause, then perhaps their plan would create some amount of justice, but it doesn't. And that leads to the second voting issue, an unprecedented policy. Now, we need to jump into this legal argument about whether or not they are legally separate. Now, if you remember the quote they read to determine whether something is a legally separate entity, one of the tests was whether or not they were able to act independently with one another. That's good. I direct you to the evidence my partner read, in which the State Department officially declared that Chinese SOEs are unable to act independently of the People's Republic of China. The very standard the Affirm Team's court case laid out. But furthermore, I'd like to point out the Affirm Team never disagreed that never in the history of U.S. law have we targeted a specific company or targeted a specific country and said that they will not be able to make a certain legal argument. That's never happened before, ever. Instead, however, the Affirm Team claims to want justice, but apparently they're not offering justice, they're only offering discrimination. Discrimination against certain companies within China that are only claiming the legal status that dozens of other countries have and will continue to claim, which leads to the second voting issue I have, an illegal policy. Now, in the last 10 seconds of the speech, Isaac responded to this disadvantage by saying, that's about trade, that's about tariffs, that's not about U.S. law. The Affirm Team is incorrect. Specifically, when it comes to the dispute settlement process, the World Trade Organization sets out that you cannot discriminate in economic disputes against one nation. If it's true what Isaac said, that this is about U.S., that it doesn't apply to U.S. law, I would kindly remind them that tariffs are often passed by U.S. law. So that's a logically incomplete argument. But furthermore, ladies and gentlemen, if what they're saying is true, and if this case is about justice, then their claim is specifically discriminating in violation of international law against the People's Republic of China. And finally, the Affirm Team has completely dropped the court case we brought up that Benjamin has continually referred to as the two responses to the legal separation argument. So, ladies and gentlemen, if Robert Silverman were here, what would he get with the Affirm Team's plan? He would get nothing. Absolutely nothing.
The Journal of Transnational Law and Policy put it perfectly when it said this: "It is well past time the U.S. amend the FSIA to adopt the internationally recognized rule, which provides that state-owned entities, with their separate legal personalities, are not entitled to assert sovereign immunity." As I said in my first speech, the question that the ground comes down to is this: should entities legally separate from the sovereign be granted the sovereign's immunity? We believe the answer is no, and we hope you do as well. So let's move on to the voting issues. The first voting issue is that this court case was remanded to a lower court. It was never dismissed because of a lack of subject matter jurisdiction. I have two responses. It was dismissed in that lower court, which the negative team never responded to. And my second response is that was just in the veterans case. That was just in the veterans case when it was remanded. In the CNBM case, it was dismissed in its entirety and was not remanded to any lower court. So the fact is yes, in the veterans case, it was remanded to a lower court, but they, in the end, did dismiss it as well because of subject matter jurisdiction. But the point my partner was trying to bring up through that argument was not necessarily that it was remanded to another lower court. It's that the reason why the case had to be even dismissed from the court in itself was the jurisdiction. The court didn't have jurisdiction. What our plan does is it gives that court jurisdiction. So So regardless of the FSIA, they would have jurisdiction to allow that suit to be brought forth on the merits of the claim, not whether or not they are continued to be or considered to be a part of the government. But talking about that, they said this is a feel-good policy, they can already be sued. And they said, well, we're changing our plan in today's debate round. We're not merely clarifying, we're changing it. But I'd like to read you the text of our plan, and it says we're going to extend U.S. court jurisdiction. And as my partner read a part of evidence about the FSIA currently gives, under the agencies and instrumentality section of the FSIA, it gives immunity to a separate legal person. It gives first to the organs of the state and a separate legal person under the state as well. So that means that right now, U.S. court jurisdiction has no claim over a separate legal person under the state. But I'd like to talk a little bit about this, because they said this is an unprecedented policy. My simple response is this. They never responded to the question I asked in cross-examination, which is, are you aware what the Supreme Court ruled before the FSIA? And they said, well, the State Department said that they can't act independently. The de facto versus, de facto just means as a matter of fact. It doesn't mean legally. And I'd like to read a part of evidence backing this up, that showing you that they are indeed a part of the Chinese government. According to Timothy Hill and Mark Lin, they say this: as early as 1979 in the fireworks case, the PRC, or People's Republic of China government, submitted to the New York courts that SOEs were independent legal persons with their own rights and duties, which can sue and be sued in the courts independently. That remains true today. According to Wang Huli, who's the director of the Department of Treaties and Law for the Ministry of Foreign Affairs of the People's Republic of China, he says this: it must be emphasized that the principle of state jurisdictional immunity applies to states per se, and to state organs, but not to enterprises and corporations, since they have separate legal capacity. The latter should not enjoy immunity from the exercise of jurisdiction by foreign courts over disputes arising out of their transnational activities, end quote. The fact of the matter is that according to the director of the Department of Treaties for the Foreign Ministry of Foreign Affairs of the People's Republic of China, the Chinese government themselves, they say that state-owned enterprises have their own separate legal capacity. They are not a part of our government. So regardless of whether or not there's control over these enterprises by the Chinese government, they are still separate legal entities. This leads me to the next main point that the negative team talked about, how this is unprecedented policy. Let's look at the Supreme Court decision. Because in Plaintiff's Bank of Georgia, they said this: the Supreme Court rejected the plea, reasoning that the bank was an entity legally separate from the state. This is according to the Tolling Law Review. The case firmly entrenched in American law the rule that a state-owned corporation does not enjoy sovereign status. Over the next century, this objective standard served as a bright-line test until Congress passed the FSIA. So before the FSIA, Congress agreed, or the Supreme Court agreed with the affirmative team's plan, that if you're separate from the sovereign, you should not be granted the sovereign's immunity. The Supreme Court decision was Plaintiff's Bank of Georgia. Their final point was we should not be targeting one country. My simple response is the U.S. tailors law to the problem all the time. And not only have we shown that China is the problem here, but the Chinese government sides with the affirmative team. So when the Chinese government is the only government that's been presented in today's debate round that actually wants their SOEs to be sued, then why should we not tailor our policy to fit that request? My third response is that we're here to debate about China. We're not here to make the perfect policy that applies to every government. We'd love to, but the NCFCA has asked us to debate about China, and that's exactly what we're doing. They dropped, all their evidence was from James Stapleton. They also dropped the discovery process. Now that currently denies Americans justice, and at the end of the day, we don't believe entities legally separate from the sovereign should be granted the sovereign's immunity, and we hope you do as well.